We might just get started. Good afternoon, everyone, and thank you for joining. I would like to begin by acknowledging the First Nations custodians of the land on which we meet today. For me in Brisbane, I acknowledge the Yugara and Turrbal people and pay my respects to elders past, present, and emerging. I would also like to acknowledge the Aboriginal and Torres Strait Islander people who are joining us online today. We pay respects to their elders, law, customs, and creation spirits. We recognise that these lands have always been places of ceremony, teaching, research, and learning, and we acknowledge the important role Aboriginal and Torres Strait Islander peoples play in our community and improving our legal system. My name is Alicia Kelly, and I'm the Acting Executive Director for National Legal Aid. I would like to welcome everyone to the webinar on changes to the NDIS and what this means for lawyers. We have, of course, our colleagues joining from our legal aid commissions, but also would like to extend a warm welcome to our colleagues in specialist disability legal centres and community legal centres who we know have registered for this training. This webinar is public and recorded, which we hope means it becomes a useful resource for the legal assistance sector. In March 2024, the Australian Government introduced changes to the NDIS Act 2013 through the National Disability Insurance Scheme Amendment, getting the NDIS back on track number 1 Bill 2024. The bill passed in August and the changes will come into effect on the 3rd of October 2024. Lindsay Ash, Senior Solicitor of the NDIS Government Law Team, will cover the 5 main changes to the NDIS legislation, including access, supports and debts, and what this means for the work that lawyers do in this area. We will have some time for questions at the end of the session, during the course of the session, which you can put into the Q&A function. Please get thinking and start inputting questions during Lindsay's presentation. Thanks so much, Lindsay, and hand over to you.
Thank you very much. I would also like to acknowledge that I am presenting from the unceded land of the Gadigal people of the Eora Nation and pay my respects to elders past and present. So today I'm going to be presenting on some of the changes that we can expect thanks to the NDIS, getting the NDIS back on track bill/act that is about to commence this week. I think it's fair to say that although the changes are substantial, there's still a lot that we don't know, and at least 25 plus rules instruments that have to come in to support these changes. So this presentation will be based on what we know now. Please feel welcome to put questions in the chat or comments or clarifications, anything you want as we go through. What we'll talk about today is just a bit of a recap about the NDIS review and how we got here, and then going through the 5 main changes that the Act introduces. Those are around access, new powers for revocation, a new definition for NDIS supports, new approach to planning, and then managing, using and acquitting funding. For each one, I'm just going to go through what the main changes are and then practically what I think that might mean for the work of lawyers in this area. And then finally, just to go through the timeframes, when do these changes commence and what other changes are on the horizon. So to start off with, the NDIS review was a very expansive review of the NDIS involving a lot of consultation, and it made a large number of recommendations, 26 recommendations, and those were accompanied by 139 actions that need to be taken to change the NDIS. I think it's useful while we're talking about these changes, while they are substantial, to talk about the number of recommendations that were made as part of the review that aren't part of the bill, and so how much more change we can expect in the future. So I'll just go through what the main recommendations of the review were. So the first one was a system of foundational supports intended to be available for all people with disability, some of which would be general and some of which would be targeted to the individual. The second thing it recommended was a more consistent participant pathway, including more transparent methods for assessing access to the scheme. The third was reform to the early intervention pathway, including for children under 9 and for people with psychosocial disability. The fourth was for plans to no longer be line by line, but to contain whole of person supports based on needs assessments and with more flexibility in the use of funding. The next big change was for navigators for all people with disability to eventually replace support coordinators and plan managers. Next, reforms to supported decision-making and the appointment of nominees. Next, reform to home and living supports with a recommendation that shared supports be the default for home and living supports. The eighth big change is more market intervention and provider panels, including in rural and regional areas and in First Nations communities. The next is for people who are aged over the age of 65 to be able to access both the aged care system and the NDIS. And finally, a recommendation that all providers are required to be registered or enrolled. I've used a traffic light system to try and indicate what of these changes are part of this Act. So I would say that changes 2 and 3 around the access criteria and differences between the access for disability and for early intervention have been partially achieved by this legislation, and plans, the changes to plans are wholly achieved, but there's many other changes there that are yet to make their way into legislation. To be fair, the system of foundational supports requires a response across state and federal governments, so it wouldn't be part of this legislation. And you may know that there's been a negotiation around those foundational supports to begin to be available around the middle of 2027. Okay, so these are what I think are the 5 biggest changes that we can expect from this legislation. The first is that which access criteria the person has met will matter. The second is that I think we can expect that cohorts of existing participants may face revocation. The third is that NDIS supports will come from a defined list. The fourth is that participants eventually will transition to longer plans based on needs assessment. And finally, there will be more limits on the management of funding and more consequences for failure to properly use and acquit funding. Okay, so let's go through each of those changes one by one. Firstly, to talk about access. So as most people in this room would know, if they're assisting people with NDIS issues, there are 2 different ways in which a person can meet the access requirements and become a participant in the scheme. First is by meeting the disability requirements, and the second is by meeting the early intervention requirements. The NDIS review said that there wasn't sufficient difference between the pathways, that there wasn't, that it was intended that early intervention pathway would look different to the disability pathway, and that those should be more different in the future. So these changes are to begin a process of things looking different for participants in the scheme if they are early intervention participants or disability participants. And we don't entirely know what eventually the early intervention pathway will look like, but we know that these changes are to pave the way for that to happen and for those things to look different. So we know that when a new person seeks access to the scheme and is granted access to the scheme, they will receive a decision stating whether they met one or both of the early intervention and disability requirements. Separately, new participants and at some point in the future, existing participants will get a notice saying which impairments they satisfy the criteria for. New participants will get that from the 1st of January 2025, and there will be a process over time for existing participants to get a notice like that. There'll also be a fresh decision about which requirements are met with each new plan as part of a needs assessment, which we'll talk about later. And so from this, we can expect that supports for each cohort of participants are likely to be different. And we know that they'll only be in relation to impairments that meet the requirements or have been found to meet the requirements. Okay. So what does this mean for us and for our clients? When someone is applying for access or has been knocked back and is seeking review of an access decision, we'll need to be advising clients about what's the best argument. Do they meet the disability or early intervention requirements or both? We'll also need to be advising people about which impairments, which are categorised in the legislation, as they always have been in the access requirements, but again spelt out when it comes to people getting notices of impairment, that there are categories of impairment, and we'll need to be advising people which impairments, whether it's intellectual, cognitive, neurological, sensory, physical, or psychosocial, or any combination of those, are likely to meet the requirements for access to the scheme. These decisions are going to impact on the supports that a person receives. And so I think it's important to be thinking about this now in terms of how we can best sort of put forward people's cases in terms of access to the scheme. The other thing to say is, though, that there will be future decisions about the basis of access to the NDIS for someone. So although it's important to get things right at the very first application, each time a person has a needs assessment, there will be a further decision, further exploration of the basis of access to the NDIS. So while it's important to get it right for the first time, and we'll certainly set somebody up as well as possible, it's not necessarily going to be it won't be the only decision about the basis for somebody's access to the NDIS, and that will be progressive as long as they're a participant in the scheme. The other thing we need to be thinking about is when somebody has gotten access to the scheme, but they say that the basis for that access isn't right. Unfortunately, the Act doesn't change people's review rights in relation to decisions for access. So it's not possible to seek review of a decision that you meet the requirements to access the scheme, but not the ones that the agency has found. I suppose that is because there's going to be subsequent decisions about it, and those ones are going to impact on the person's rights more substantially as they go along. So what they can do is eventually, when these notices of impairment are available, people will be able to seek review of a decision about varying the notice of impairment to include other impairments or potentially to remove impairments that the agencies recognise, but more likely to include additional impairments. And of course, they'll also be able to seek review of decisions to approve the statement of participant supports, which is going to include a decision about the basis for access. And obviously, whenever I'm talking about review, I'm talking about an internal review, which needs to be made within 3 months, and then externally at the moment to the AAT and soon to be to the ART within 28 days. I might just check whether there are any questions about that first change. Doesn't look like there are. Just give a minute for anyone who wants to ask a question about changes to access. Okay, and then I'll move on to change number 2. The second big change is around revocation. So the first thing to say is that there's always been a power in the Act for someone's status as a participant to be revoked if it's found that they no longer meet the disability or early intervention requirements to access the scheme. What this new Act introduces is new powers for the agency to request information from people when they are considering revoking somebody's participation in the scheme. So the agency can write to a person and ask them to provide further information, or can ask them to undergo an assessment and provide the results of that assessment. They're only allowed to make these requests where the information cannot otherwise be reasonably obtained. If the request is not complied with in time, and the standard timeframe in the legislation is 90 days, noting that that can be extended or changed, then if the person has not provided that information, then the agency is able to revoke the participant's status. They must not do so if it's considered that the non-compliance was reasonable, and there's a set of factors in the legislation about what might be taken into account, as well as the potential to add further information through the rules. One example of where non-compliance might be reasonable is where it was not in the participant's control, their ability to obtain that information. So that's added to Section 30 of the Act, which already included a power to revoke people's participation from the scheme. But the Act also adds a new Section 30A, which includes an additional revocation power. The basis for that, or the reason for that's not really clear on the face of it. The only way it looks different from the existing Section 30 is to say that the agency has to consider whether the person meets the early intervention requirements first and then the disability requirements. So it just shifts up the the order of the consideration. The explanatory memorandum tells us that the purpose of this section is to look at early intervention participants and whether supports are working appropriately or have worked and done their purpose for early intervention participants. And so I think we can expect that this power might be exercised in relation to existing early intervention participants in the future. But we're waiting on rules to know exactly how it's intended that this will be applied. So what this means practically is that we might see participants starting to receive notices requesting information or assessment and asking them to reply within the time frame, and they must reply within that time frame or face revocation. We might be assisting people to provide the information, looking over it, helping to or organise that practically, or we might be explaining to the agency why they already have that information or can reasonably obtain it and so shouldn't be relying on that section. We might also be helping participants to explain why they can't comply with the requests, or we might be asking the agency to fund the assessment that they're requesting. The new sections and the new powers don't include any information about how practically a person goes about getting that assessment or who will fund it. So similarly to the existing powers around accessing the scheme and the powers to request information there, it's left a little bit ambiguous who, if it's possible, I suppose, to for the agency to pay for those assessments. The agency has a general obligation under Section 6 of the Act to help people to comply with their obligations under the Act, including financially. So I think there's an argument that if somebody, it's just not possible for somebody to afford an assessment, that the agency should step in and fund it. But there's nothing express in the Act to say that that has to happen. So I could imagine that that might form part of the work that we're doing once these changes are in. As they can now, clients whose status as a participant has been revoked can seek a review of the decision, and they would either be looking to establish that the discretion to revoke for failure to provide information was incorrectly or unfairly applied, or like they can now, they would be establishing that they do meet the disability or early intervention requirements or both, and that it was incorrect for the decision maker to have exercised their discretion to revoke. I think as we sort of start to get our heads around these changes, we might be thinking about how we might run these different types of revocation differently, sort of acknowledging that a person who has been revoked from the scheme doesn't have access to any supports. It might be that we are arguing that when somebody hasn't provided the information, that that decision is set aside and they're given a further notice to provide information by a particular time so that they can get back onto the scheme and accessing supports. I think that's a little bit unclear at the moment, but it is a real challenge of that type of matter, that a person is being asked to provide information about how they meet the requirements, but generally without the supports that they have had up until that point, including practitioners who can provide information and potentially support workers or other people who can help them to attend appointments and so on. So that is change number 2. And again, I might just see if there are any questions and give people a notice to give people time to ask any questions. I've been asked if there's any requirement when issuing the notice for information that the agency give details about why they consider the participant may not meet the access requirements. It's nothing expressed in the legislation at the moment, but acknowledging that there might be more information that comes in the rules. The idea behind this is that there's already an existing power for access to ask people to provide further information to help the agency make decisions, and also for supports. And the intention is that this will mirror those existing sort of powers and requirements. So as far as I know, there's nothing in the legislation. It might come into the rules that there would be detail about why the person doesn't meet the access requirements. You may be able to infer from the type of request that's being made, whether it's a functional, a request for functional information or a request for information around permanency. You may be able to sort of infer it, but there's nothing express in the legislation about that. Okay, I think that's the only question at the moment on that. So we'll move on to the next big change.
I think one just came through the Q&A.
Always the way. There's situations you consider it would be better to review a revocation decision as opposed to lodging a fresh access application. I would always think it's better to lodge an application around revocation as opposed to fresh access for if you're within time. The reasons behind that is that revocation is discretionary, so it might be possible to provide information about why the agency should not have made that decision. And I think it might also be possible, although this is still unclear, it may be possible to apply for a stay of the decision, where it isn't possible to apply for a stay of any decision when somebody's seeking access again, because there's nothing to stay. I think that's a bit of an open question around revocations that hasn't really been resolved, because in my experience, we haven't seen that many of them. So I would think for those two reasons, it would be better to seek review of revocation. I suppose it also just puts you a little bit further along the path as well, rather than applying again. Okay. All right. So the next change is that NDIS supports will soon be defined. So what we're used to at the moment is the reasonable and necessary criteria and the supports for participants rules, which say that if a support meets the criteria and isn't generally excluded by the rules, which are fairly broad in their application, then a support can be funded sort of regardless of what it is. There's going to be a really significant change in the way that works when this legislation comes in, and very soon after, when the list of supports is made into a transitional rule. So from that point on, the definition of NDIS support says that there will be rules that say what is and is not an NDIS support, and that and participants will be expected to only pay for or use their funding under their plans for things that are NDIS supports. At the very last minute, there was an addition to this section to say that a person can apply for something that's not generally an NDIS support, and the agency can decide that they will fund it if it would replace something else and it's cheaper and better than the thing. So that's an extra sort of process that is added into the definition. It's pretty rare to have a process of having something recognised in a definition section. And we've got a bit of thinking to do about how that interacts with the decision to approve a statement of participant supports. I suppose we'll get onto this when we talk about what plans are going to look like, but in the future, they'll contain a chunk of funding for flexible funding for supports. And it's possible that really what this decision would do is just direct it or allow a person to use that funding for something that otherwise wouldn't meet the definition. And so it's possible it would not be part of the decision to approve a statement of participant supports. But I think we're just going to have to see how the list works and how that works in practice. This type of decision that you can apply for to ask for something to be recognised isn't a reviewable decision in and of itself. So we just have a little bit of thinking to do about how it interacts with other review decision or other review rights that people might have. There's also just an express part of the definition that says that a support is not an NDIS support if it consists of sexual services, alcohol, or drugs. So there is a draft list of supports that's currently circulating and will become a transitional rule very soon after the Act comes into effect. And that's because the Act needs that transitional rule to work. I don't know how many of you have had a look at the draft list of supports. In my view, it doesn't drastically change the supports that are now available under the NDIS. It also sort of still has some issues that we would have seen in our casework. So issues that have arisen in terms of proving certain supports ought to be funded have been around whether it's the NDIS or another system that's more appropriate to fund the support. And at the moment, some of the wording around some of those divides that was already unclear has been replicated in that draft list of supports. So we might still see issues with that in the future. But I couldn't say that there were large sort of things that are available under the NDIS now that people wouldn't be able to access under the rules. But there will be a fair bit of work to go through exactly what they say in the future and work out if there are significant changes for people. I've got a question going back to the access part of the presentation about should we be trying to negotiate impairments to be added into support matters currently in the AAT. For example, where there's already access for a psychosocial impairment, but the applicant needs physical supports for a separate physical condition. This is a really difficult question and one that I think we can't answer conclusively at the moment because when we get to the supports definition, we'll be looking at, so there's been a new section that's been added to say that supports have to relate to an impairment for which the person meets the access requirements. And there is in the future an intention that people will get impairment notices to say what impairments they have access to the scheme for. But in that period of time between now and then, it's really unclear what people can do in order to have impairments recognised. There's no process for it, and there's no legal process for it either until those notices of impairment come in and the right to seek review of those is enlivened. I know that sort of anecdotally people are asked to provide information about their impairments in the course of support matters, and maybe in the past we've told people that that's not necessary because there was no such sort of specification in the supports rules that a support had to relate to a particular impairment. I think all I can say at the moment is we don't really know. We know that supports have to relate to an impairment, but people are not at the moment being given a clear idea of exactly what impairments have been recognised or how they can go about getting other ones recognised. I'm sorry, that's not a perfect answer to that question, but I think we don't know yet. Okay, so what's this gonna mean for us and our clients practically? So from now on, plans approved and varied after this new definition commences, which is the 3rd of October, will only contain funding for NDIS supports. And depending on what the transitional rule looks like finally, participants might need assistance to determine whether something is or is not an NDIS support. There isn't a mechanism to seek clarification from the agency about whether something is an NDIS support or not. And so I think that's going to be a difficulty depending on the wording of the supports for people to work out whether they are able to use their supports for, use their funding for certain supports. We'll talk about this a little bit later, but using funds on non-NDIS supports can lead to other decisions being made in the future to restrict the flexibility of people's funding, to restrict the management of their funding, and also debts. We'll talk a bit more about that. In future access applications, so what's now section 24(1)E and also the sort of equivalent section under early intervention, what now says that you have to show that you need the support of the NDIS for your lifetime will soon say that people have to show they need NDIS supports for their lifetime. So a much more sort of concrete requirement to point to the list of supports and establish that you require something or things under that list. Practically, people will be able to make applications, sorry for the typo, for declarations that they can use their funding on supports that are on the no list. Any questions about those requirements? Just move on and come back to those if there are any. Okay, the next big change is around what plans are going to look like in the future. So there's a system within the Act to transition people from what are being called old framework plans, which is how things are now, to new framework plans. And a new framework plan is going to be a plan that goes for longer and is split into different funding periods that can be up to 12 months. So we can expect that people will have much longer plans under the system of new framework plans. Those plans will be based on a needs assessment, the details of which we don't know too much of so far, but that will form the basis of establishing somebody's need for certain types of supports, and then a formula will be applied to calculate the supports that a person receives under a plan based on that needs assessment. The needs assessment itself will say whether the person meets the disability or early intervention criteria or both. The plans will contain a certain amount of flexible funding that can be used on any NDIS support. There are some limitations that can be put on flexible budgets or apportionment of them to different purposes or management styles. But the idea is that rather than having a line-by-line list of the supports that have been approved, a person has a budget, and if the supports are NDIS supports, the budget can be used for those supports. They'll also contain certain funding for certain stated supports, which is likely to be things that we have at the moment with a fixed price, like equipment or home modifications, and stated supports can only be used for that purpose. So we know that the needs assessment will use a tool that hasn't been developed yet, that it's possible for the needs assessment to take into account information from other sources, and the agency is sort of directed within the legislation to take into account other information, and will identify a person's support needs. And there's a notation to say that to acknowledge that someone's environment and also non-permanent impairments might affect their support needs as well. Needs assessments can be replaced if the NDIA or the reviewer considers it necessary because they no longer reflect the needs of the person. And consequently, when somebody is seeking review of a decision to approve a statement of supports in one of these types of plans, the person can say that the needs assessment ought to be replaced because it doesn't reflect their needs. Okay, so what does this mean for us and our clients practically? At the moment, not much. So not much in the short term. This is a transition that the legislation says has to be completed within 5 years. And there's a lot of people to transition to this new system, and a lot more, I think, work that needs to be done to establish and implement a needs assessment tool. So what's going to happen is participants will get a notice of when they're transitioning to a new framework plan, and the first step when that happens is that they will be requested to undertake a needs assessment, because the needs assessment is really key to working out what criteria the person meets the eligibility for, what their support needs are, and what their budgets will be. A person can't really transition to a new framework plan until they've had that needs assessment. And so the first step is to be asked to undertake a needs assessment. If the person doesn't respond or refuses to participate in a needs assessment, their plan, which includes their current sort of old framework plan, can be suspended, and the decision to suspend a plan is reviewable. So what can people expect in the meantime? Well, until that transition happens, participants will have old framework plans, which are the same as they are now with some differences. So as we've talked about a little bit so far, supports can only be for impairments that meet the access requirements, and funding can only be used for NDIS supports that are on those lists. There's also sort of changes to the structure of those old framework plans to make them also possible for them to be longer, and also split into funding periods of up to 12 months. And also there's also some provisions around specifying the total funding amount under those plans, and potentially how types of supports can be categorized and grouped together. So that requires an instrument that we don't have the details of yet, another transitional rule. But I think what we can sort of expect is that old framework plans will start to look a little bit like new framework plans in terms of the length that they go for, length of time they go for, and the grouping of supports into particular categories. The question is whether there will be additional funding provided to participants to obtain a needs assessment. I don't think we have that detail yet. I think what we know now is, I think we can assume that that the agency will organise and fund the needs assessment, but we don't. I don't think we concretely have that confirmation yet. Are there any other questions about needs assessment or new framework plans? No, okay. All right, so moving on to the final change. which is actually 3 changes, but saying that there were 7 changes wasn't that snappy, so I went with 5. So these changes are around managing, acquitting, and using funding. And here are the sort of main things that are going to change. For management of funding, there are now extra grounds to refuse a plan management requests. So for self-management, there is a new ground that if the participant or nominee who's seeking to self-manage has been convicted of an offence punishable by imprisonment of 2 years or more, or an offence involving fraud or dishonesty, their funding must be agency managed with no discretion. And for self and plan management, the agency can refuse a plan management request if they consider that the person would be unlikely to comply with their acquittal obligations. It's probably worth saying at this point that there's always been an obligation under the Act to acquit funding, but this obligation is being referred to many more times in the legislation and in relation to decisions that can be made about how someone manages their funding, how their funding can be used, and also debts. So in new framework plans, similarly, the agency can make management decisions about proportions of flexible funding. So decide that a certain proportion of a flexible budget has to be managed in a particular way, taking into account these considerations, as well as the existing considerations around unreasonable risk. For acquitting funding, the participant, as I said, has obligations to acquit their funding, which includes using their funding in accordance with their plan and using it on NDIS supports. And the NDIA will take whether the person has correctly acquitted their funding or is likely to acquit their funding into account when making other types of decisions, like just the decision to approve or vary a statement of participant supports. It's been added in as a consideration for around making those decisions. It will also be taken into account in determining how funding will be managed under a plan and restricting the use of flexible funding. And then finally, around using the support in a plan. So there's always been a section that allows the agency to raise debts against participants or other people, but the change that the legislation makes is to really make it clear that a failure to use funding appropriately can lead to or a failure to use the funding on NDIS supports can lead to raising a debt against a participant. The Act allows for a debt to be raised against a participant or another person, including a person who's received the funding, but doesn't provide any guidance about how to choose between those people. So it's possible that debts will be raised in any situation where funding hasn't been used on NDIS supports or in accordance with the plan against the participant or against another person. The Act also brings in some new provisions around paying amounts above what's already in a plan. So the Act will prohibit the agency from paying an amount beyond what's in the plan unless there is a factor or consideration that has been enlivened, including if the person has experienced financial exploitation, if there's an imminent risk to the participant, a reason why they haven't been able to request a change or variation to their plan, or they have made a request for a variation for crisis or emergency funding, but there's no decision been made on that yet. So those will be the circumstances in which the agency can pay an amount above what's in somebody's plan. They've also included a new rule or section to say that claims have to be made within 2 years of a support being provided. So practically what this might mean for us and for our practice is that we might see more decisions about refusing self or plan management because there are new grounds and some of them are mandatory. There could be more decisions consequential to people's acquittal obligations. So we may be looking to assist people with waivers of decisions around debt or reviews of restrictions on the use of flexible funding or of funding within the plan and on the management of the funding. I suppose it's important to know that there is no reviewable decision in relation to the raising of a debt. The reviewable decision is around seeking a waiver or write-off of a debt and being refused. So we might be assisting people to initially seek those waivers or write-offs and then to seek review both internally and through the tribunal if that's refused. We might be assisting more participants to seek assistance, sorry again for the typo, with crisis or emergency funding variation requests. And we might see, well, we will see limitations on paying amounts above what's specified in plans, and that might affect how we approach our support matters, and it might affect the agency's sort of view on remittals and reassessments of plans throughout an AAT review process. Are there any questions about those changes? Oh, okay. Well, the last sort of big thing to talk about is what are the timeframes for all of this and what can we expect? So noting that a fair bit of this is to happen this week. So first off, the Act commences on the 3rd of October, and it has a series of transitional provisions about when certain changes will apply. They're extremely complex, and if anyone wants to ask anything or clarify anything about this, please let me know. So the changes around access provisions, the changes around access provisions apply to new applications for access that are made after the Act commences. The powers for revocation apply immediately for any person who's currently a participant on the scheme. So those powers to request further information will apply to anybody who's already a participant of the scheme on commencement. Changes to include considerations around acquittal also apply immediately and become factors in decision making from the 3rd of October. Any changes around old framework plans, so those changes around supports only being able to relate to impairments for which you have access to the scheme, and supports only being NDIS supports, apply to new and varied plans after the 3rd of October. There's one small thing that won't change, which is that what I discussed before about there being a need to work out total funding amounts and how to group certain supports and how to specify certain funding amounts. That requires a legislative determination in transitional rules, and those aren't available yet. So that part of it won't take effect until that has been introduced. Changes to special circumstances waiver, which I didn't mention, but some of the changes are to remove, frankly, unfair part of the debt waiver provisions, which said that special circumstances couldn't take into account somebody's financial hardship or disability. That's been amended to now say that, similar to Social Security's legislation, that it's not financial hardship alone, but financial hardship can be a consideration, and disability has been removed as an excluded consideration for debt waiver. So those changes are going to apply to existing debts that exist before the legislation commences and any debts raised after the legislation commences. And those plan management restrictions, so restrictions on people being able to manage funds if they've been convicted of certain offences, and the consideration around acquittal of funding, that will apply to new and existing arrangements around plan management at the date that this commences. On the 8th of October, the legislation says that a statement of proposed timeframes for rules must be published. And that is the point, I think, when we'll start to know when we can expect some of these changes that are a bit more staggered to come in. As soon as possible after the Act commences, there can be transitional rules that are made about what is and is not an NDIS support, the timing of when people will transition to new framework plans, the needs assessment tools, the method for working out funding in new framework plans, and the process for and considerations for replacing assessment. So these are all individual sections that require rules, but as we know, the rules, a lot of rules require a pretty complicated process of agreement and consideration by the states. So this allows for transitional rules to come in the meantime, and these are the categories of transitional rule that can be made. They can all be made and can be in effect for 12 months after the Act's commenced. So this means that by the 5th of October, or the 3rd of October 2025, they all have to be replaced with proper rules. The question is, does this mean that 34.1AA, which is around the impairment and supports having to be related to an impairment for which somebody has access, doesn't apply to current proceedings unless varied? I think a strict reading of that is yes, but I think that I think it requires a little bit more thinking around exactly what happens once the proceedings are finished, whether the creation of, whether what happens after a decision's been made involves the creation or variation of a plan. And also, I think it is just possible for the agency to vary a plan in the course of proceedings, and therefore it becomes a new framework plan, which then has that requirement applied to it. So I think that's the answer, that technically, yes, but practically there are so many things that just mean that it's probably likely that even if you did get that result, that the plan might change in some way to mean that that it wouldn't be possible to avoid that requirement. But if anybody else wants to I know lots of other people have been putting thought into how how this sort of transition will work and the commencement of that section will work. And if anybody has any other comments or questions that they want to add about that, just do so and I'll read that out. But I think I think technically yes, but probably practically it could be superseded or overridden in the course of proceedings. Okay, so then the next thing to happen is that from the 1st of January, that's when new participants, people who've been found to meet the access requirements, will receive these impairment notices. And at some point after that, other participants as well. And then by the 3rd of October 2029, there needs to be a 5-year review of the legislation. And by then, also all participants have to have moved to new framework plans. So I've absolutely zipped through that content, but that is the content for today. And in summary, just to go back over the big changes. So the first big change is that which access criteria a person has met, whether that's the early intervention requirements, the disability requirements, or both, is going to matter. The participant experience for people who have met the disability requirements and early intervention requirements will be different. At some point that will become clearer in the future. And we know that supports will only be in relation to impairments that meet the criteria within those 6 categories that already exist in the legislation. That means for current access applications, although it's probably arguable that the old law would apply to those access applications, there's going to be a series of decisions after that, including around people's supports that restrict their supports to supports that relate to impairments for which they've met the access requirements. So I think that strategically it makes sense to be trying to assist people to establish access to the scheme in relation to as many limbs and as many of the impairments as possible. So so I suppose looking at people's impairments now and which ones arguably do meet all the criteria in an access decision, though it won't be the only decision made about someone's basis for access, sets them up properly for their first plan and going forward from there. So it makes sense for perhaps our access reviews to be a bit more expansive than they have been in the past. We can expect that in the future that cohorts of existing participants may face revocation, and that could be from new provisions that allow the agency to request further information from people, and also that they undergo assessments and allow the agency to revoke people's participation in the scheme if they don't provide that information. And it might also be from the new section, which looks fairly similar to the existing revocation section, but we understand will be specifically for looking at early intervention participation in the scheme. From as soon as the Act commences and that support list commences, supports can only come from a defined list, which includes everything that is an NDIS support and is not an NDIS support. And so participants will have to become quite familiar with that list to know whether they're eventually, when they transition to new framework plans, there'll be flexibility and decision making to be made about whether what people are purchasing is an NDIS support or isn't. And immediately with the use of plans, that obligation to only spend funding in relation to NDIS supports will exist. NDIS supports then also becomes the focus of the final access requirement, so whether or not the person needs NDIS supports for their lifetime. And there's also a possibility of making an application for things that aren't on the list to be included by application to the agency, and we need some more clarification about how that's going to all fit in with existing decisions around planning and supports. Within the next 5 years, participants are going to transition to longer plans based on needs assessment that are called new framework plans. People will receive a notice notifying them that they are to transition and asking them to participate in a needs assessment, and they can have their plan suspended if they don't participate in the needs assessment. How that planning will look is there will be a tool which is yet to be developed or yet to be published what that is, that will determine somebody's support needs for both stated and flexible supports, stated supports being things with a fixed price with a particular purpose where the funding can only be used for those things, and flexible supports being a budget that a participant can use to purchase any NDIS supports. And the needs assessment will also contain a decision about the basis on which someone meets the access requirements. So that transition is going to happen in the next 5 years. And in the meantime, plans will look fairly similar to what they look like now, with some more restrictions on the use of supports in those plans, as we've discussed. There will also be more limits on the management of funding and more consequences for failure to use and equip funding, including restrictions on management, restrictions on the use of portions or whole parts of flexible funding budgets, and the possibility of debts. Concerning acquittals, the question is, can the NDIA raise a debt against the plan manager for allowing a participant to purchase non-NDIS supports? Or do you think the participant may be liable? I think the answer to that is yes. I think that the section just says that, I'm not sure actually. I might have to check that. There is certainly a person who's received an NDIS amount can have a debt raised against them, so a provider, but I'm not sure whether it's possible to raise a debt against a plan manager. I might just need to take that one on notice. But certainly a participant could be liable in that situation, even if it was the plan manager's advice that caused them to purchase the support. That's something that we submitted ought not to be the case, and that participants should be able to clarify whether something is an NDIS support and be able to act on and trust the advice of the NDIA support coordinators and plan managers. There's no sort of consideration of that in the legislation at the moment. All right, might just allow for any other questions and leave up the summary of what the changes are. Has Legal Aid had any information about the transitional NDIS support list and whether it will be changed significantly from the draft? And will they only be available on the 3rd of October? Don't have any information about the date on which they'll be available. I know there was a consultation process on that list, and I know that there was a really high level of consultation, or I guess a lot of submissions that went in around that list. I would hope that some things will change as a result of that list, but I don't know for certain. It's just a matter of wait and see when the list comes out about what suggestions have been taken up from those submissions that have been made in the consultation process. The next question is, do you see the AAT process reducing? Will this still be an option given the decisions? So I think there are many aspects to that question. So I think I can see the AAT process for access to the scheme expanding, because we need to be thinking about all the possible avenues for access for a person and having as many impairments recognised as possible. I think for supports for old framework plans, things will probably look fairly similar, because people still need to meet the reasonable and necessary criteria in relation to individual supports. I can see potentially it might be of a necessity that the AAT process goes a bit quicker if the new provisions cause the agency to change their position on allowing for sort of topping up of funding or remittals or reassessments of plans throughout the process. I think we'll have to see about that. In terms of the AAT process for a new framework plan, I think yes. So there are lots of aspects to a new framework decision. So that includes the basis for access, also the needs assessment. But my understanding is that what a participant might be able to say through the review process is, and this needs assessment about me is incorrect and I need a replacement assessment done. And once that assessment is done, and if a decision maker is satisfied that that does reflect somebody's needs, then what the tribunal or decision maker does then is implement that decision in the form of a plan with certain funding amounts. So it certainly won't be the case of what it is now, where a person has to show that they meet 6 criteria in relation to each individual support. And it may just be a process of saying that a needs assessment is incorrect and needs to be replaced. I can foresee a situation where people might need to be asking for that multiple times if that is the only mechanism for needs assessments to be the basis of planning. Potentially they come back inaccurate more than once. So I think yes and no is the answer to that decision. I've been asked to talk a bit about how the introduction of navigators would work. And I can't really do that, unfortunately, because it's just a recommendation from the NDIS review, and we don't know yet whether or not that recommendation has been adopted. But what the review said was that there are various forms of help with decision making in accessing the NDIS and also other disability supports outside the NDIS, and that access to those is a bit fragmented and unfair. And so there is a recommendation that everybody would have access to some form of help to work out how to navigate the NDIS. Beyond that, how it might work to replace those existing decision makers and decision supporters and other support people, I'm not really sure, and I don't think we know whether that recommendation is going to be taken up yet or not. A question around, if a client has a managed plan, can we expect any of the new notices will be sent to the plan manager, or might they only go to the client directly? I'd be expecting that they go to the client directly and to or to a correspondence nominee, so the person that the agency has on their file to correspond with in relation to decisions under the Act. It might be that they're copied, that other people are copied in, but I would expect they will go to the participant or their nominee. The next question is, do we know if access matters after the 3rd of October will receive a new framework plan and so a needs assessment, or will they get an old framework plan while missing the detail about? So at the moment, everyone will continue to get old framework plans. If you become a participant now, your first plan will be an old framework plan. If you're involved in a tribunal matter and the result of which is you get a new plan, it will be an old framework plan until people start transitioning. One of the sets of transitional rules is around the timing for moving people onto new framework plans. So we're going to know more about that then. So, but the answer is an old framework plan at the moment. As plans come due for review, do we expect them to all become new framework plans? Will current framework plans also be able to be rolled over? So the answer to that's no. We got it. There's going to be a time frame. So there will be a rules instrument that says that certain groups of people or certain cohorts will get notices to transition to new framework plans at a certain point over the next 5 years. There's no sort of automatically turning someone over into a new framework plan as the result of a reassessment or a variation. It's a separate process that someone has to be notified that they are going to transition to that new form of plan. Those obligations to only spend your funding, or that I suppose the obligations that say that the agency can't pay amounts above the current plan exist and apply to old and new framework plans. And then the next question, which is very easy, is will today's slides be circulated? And the answer to that is yes. Okay, I think so. Those are all our questions. I'll just give a minute or two for any more to come in. And say thank you very much for attending the session today. We finished early, but there's much more details to come in the future. So we can expect that we'll be talking about this much more as we start to know what the list is, when people will start transitioning, and a bit more around the ways in which access to the scheme will be different for early intervention and disability participants. There's no more questions that have come through there, so I'll just say thanks very much, everyone, for your time, and have a good day.
Thank you, Lindsay. And thank you, everyone, for your questions this afternoon. National Legal Aid will look to progress further work in this area, including a disability legal assistance community of practice. We'll email people who have registered about this and look forward to working together in the future. So thank you all for coming today. Appreciate your time.